So thank you for coming to the small claims class. My name is Dawn Miller. I'm a staff attorney at Nevada Legal Services. Just so you know, Nevada Legal Services it's basically a legal aid office. You have to be low income to qualify for our services. Part of the reason why we put these classes on is not everybody can use our office, but everybody seems to have questions about small claims. So we try to offer these classes so that you can help better understand how to navigate through the process. So the packets that I've given you are for you to keep. Usually I have a presentation behind me, but this is an exact copy of my presentation. So this is the materials that we use. Also, as I go through the presentation, I might refer to some websites and various places where you can get forms and things. All that information is in there, so you don't have to worry about writing all that down. Okay? The last thing that I ask is that you just hold all of your questions until the end. Okay, the quicker I get through the material, the more I can get to your specific questions afterwards. So I will get through the presentation and then get to you individually. Okay. So let's start off by talking about what is small claims court. Small claims court is a division of the justice court. It's designed for you, meaning you should be able to do this process by yourself without the assistance of an attorney. Most of the forms and most of the things that you'll need to complete a small claims action, they're all fill in the blank. It's very easy to do and it's designed that way. The other thing is no injunctive relief. What that means is sometimes when people are suing somebody, what they want is for a judge to order someone to do something or to stop doing something. In small claims, the judges don't have that kind of ability. They don't have the jurisdiction to issue injunctive relief. So for example, let's say you're having a dispute with your neighbor, okay, and your neighbor's dog has done damage to your yard. If you want the judge to order your neighbor to fix his fence, they can't do that in small claims. But you can go to small claims and you can recover the money that the dog did in damage to your yard, okay? So that's what injunctive relief means. Useful terms. Just kind of remember, some people do and some people don't. The plaintiff is the person who's filing the lawsuit, okay? The defendant is the person who's being sued. Is anybody here a defendant in a small claims action right now? Okay. We're going to talk more about this in a minute, but depending on where you file your case will either be heard by a justice of the peace, which is an elected position. You may see their signs throughout the city. Or you may be heard by a referee, which is kind of the same thing as a judge. It's just a little bit different. And we'll talk about why they do that in different places later on. Okay, this next slide that you have in your materials is kind of an overview of the whole process from beginning to end. This gives you an idea of where you're going to start off and the very last things you may or may not have to do. And we're going to talk about each one of these individually. The first one is deciding whether you should even file a claim and some of the things to think about in making that decision. How to collect and organize your information. The things that you're going to need in order to proceed. Third is sending a demand letter, which we'll talk about. Fourth is filing your claim with the court, and then having your complaint served. Then you will be required, no matter which court you're in, you will be required to go to mediation. If mediation doesn't work out, then you're finally going to get to court. There is the right to appeal, should either party want to do so. And also, there could be some steps in executing your judgment, which we'll talk about. We'll go through each one of these, okay? So starting off, before you actually file a claim in the court, you want to kind of think about how strong your case is. And I do recommend that you be kind of honest with yourself. You need proof. You need to actually have documents or some sort of evidence to present to prove what it is that you're alleging. If you don't have that proof, that could hinder your ability to prevail in your case. Also, whether your claim is $10,000 or less. In small claims, you can't ask for any more than $10,000. Okay? It has to be under $10,000. If it's more than 10,000 that you're seeking, you can pursue a different kind of action. Another big one is to think about whether your defendant is judgment proof, which sometimes some people know what that means and some people don't know what it means. We'll talk a little bit more about it later. But basically, it means that the person who you're trying to sue doesn't have any property that you can take. All of their property is what's called exempt property. And I'll kind of explain that in more detail. But the reason we tell you here is because if you go through this whole process and it turns out that your defendant, all of his property is exempt, protected, you'll win and you'll get a judgment, but you won't ever be able to collect it, which is very frustrating. So you kind of want to think about that before you start the process. Another thing to think about is whether your time for filing has expired. Generally, most of the time, in most cases, it hasn't. There's a little box there, a little white box in your handout that shows you the statute of limitations. Generally speaking, you have anywhere from 2 to 6 years to file your claim. A common question or a common small claims issue is recovering your security deposit. Recovering your security deposit stems from your lease or a written contract. So you have 6 years from the breach, which would be when you didn't get your security deposit back, to file your case. So you have quite a while. Another thing you want to think about before you get started is whether you're actually going to be able to find the defendant, which can be trickier than it should be. And if you can't find your defendant, you're going to have a hard time with service. So that's something you want to think about before you start rushing off and filing paperwork, is whether you actually know where the defendant is at. And lastly, you might want to just think about whether you should hire an attorney. Some cases like car accidents, or I've encountered individuals who want to sue their doctor for medical malpractice. Those are complicated cases, and small claims is probably not the right place for you, and you may want to seek the assistance of an attorney. Sometimes it's well worth the money that it costs to have somebody help you with a more complicated case. Okay, so after you have thought about some of these things that we've discussed, and you've decided that you're going to go ahead and proceed, you first want to, there's going to be several steps as to filing your claim. Before you file your claim, there's going to be several steps to that. The first is identifying who your defendant, figuring out who you're actually suing. The second is determining the amount of your claim and how much money you think you're entitled to. Step 3 is sending a demand letter, which we're going to talk about. Step 4 is going to be actually filing your paperwork with the court. And then step 5 is getting your complaint served on the person you're suing. Those are all steps in actually starting this lawsuit. So step 1, figuring out, identifying who your defendant is. Okay, figuring out who it is that you're going to sue. It also makes a difference whether you are suing an individual or a business, and if you're not sure who is responsible, name everyone in one lawsuit. So I use an example of, let's say that you're a homeowner and you had work done to your swimming pool, and 6 months later you realize that there's something wrong with your swimming pool. But you had 2 different pool companies do work on your pool, and you're not sure if it was company A or if it was company B. If you're not sure if it was company A or company B that messed up your pool, name them both. Bring them both into one lawsuit, and through the process it'll get worked out as to who's liable and who's not. Also, sometimes finding the people or person that you think is responsible or liable can take some detective work, and unfortunately I don't really have any secrets. We do the same thing that you can do, which is you can look for people and information on people using the internet, okay, through friends and family, through old employers. I think that the internet is a really good place these days with Facebook and all of that. You might find some information on somebody. The materials that we've given you also provide some websites. We have the business license website, the Secretary of State website, and the property records website. Those are all helpful in getting information on individuals and businesses. Later on, I'll discuss with you a little bit more about the Secretary of State. That's an especially helpful one when it comes to service, which we're about to get to. So, after you know who you want to sue, and you've identified the person that you're naming, or company that you're naming, now you want to actually figure out the amount that you're suing for and determine the claim amount. You do want to try and determine an exact amount. Don't just throw some random number out there, because once, if and when you get to court, you need to kind of back up why you're asking for the amount that you're asking for. So kind of be specific in what you're asking for. The best way to do that is to use receipts or estimates, and they can be helpful in helping you establish what you think you're entitled to, money-wise. Again, I remind you that you can only ask for up to $10,000 in small claims. If you believe your case is worth more than that, then small claims is not for you, and you can pursue other avenues. Also, there are certain costs that are recoverable over and above the amount that you allege if you prevail. So, for example, there's going to be fees to have your documents served, and there's also going to be fees to file your complaint. There's going to be some court fees associated with just getting through this lawsuit process. Those fees are recoverable on top of what you've asked for if you win. Okay? So if you think your claim was worth $5,000, but then you spent another $250, you can get the $250 on top of the $5,000 if you win. Okay, so after you know who you're suing, and you know how much you're suing for, and you have that clear in your head, the first document that you actually want to complete is called a demand letter. This is something that the small claims process requires you to do. So you must first send a demand letter. We recommend, and I wouldn't suggest to do it any other way, mail it certified mail so that you have proof that you mailed it. Be sure that you are polite and professional in this letter, but it can be very simple, okay? And the letter should basically include the exact amount of money that you seek, the reason why you believe you're entitled to it, a date by which to comply to you, and you should allow them 10 days, and also a statement that specifically says, if this matter goes unresolved, or if you fail to address this issue with me, I do intend to sue you in small claims. The court will want to see proof that you actually completed this part of the process, okay? And this is done before anything is filed with the court. This is the very first paperwork that's done, but it's not filed with the court, not yet. The reason why we tell you to be polite and professional is this could become part of your court record, and in a month or 2 or 3 down the road when you're in a courtroom, if you get that far, a judge may have some occasion to look at this, so you want to make sure that you just keep it simple and be polite and be professional in it. Later on, I'm going to refer you to a website where you can get samples of everything, and they have a great sample demand letter. You can just pull it right off online and duplicate it. So you're going to mail that certified to the person or persons that you are suing. You're going to wait the 10 days and see if they respond to you. In a perfect world, this might actually help you resolve your issue, and you might get a response from them, and you might negotiate, and that would be great. If you don't, now it's time to proceed with your lawsuit. Now it's time to actually go file your paperwork with the court. So the next step is filing your complaint. It's called an affidavit of complaint or small claims complaint. It's a very short, very simple form to fill out. It's a fill-in-the-blank form. You basically put a sentence or two as to why you are suing, and you put a statement in there as to how much you're asking for, and it's as simple as that. So for example, if you're trying to get your security deposit back, you would say that I am seeking to recover my security deposit from when I rented the unit at 123 ABC Street. I'm seeking $1,500, which was the amount of my security deposit. You do not need to attach any of your evidence to your complaint. All you have to do is fill out the complaint form. You should save your evidence and keep that to yourself until you get to court, okay? So it's just the complaint form. You're going to take that complaint form and file it in the small claims court where the defendant lives, works, or does business. There are 3 small claims courts. There's one in North Las Vegas, there's one in Henderson, and there's one at the Regional Justice Center, which we refer to as Las Vegas. You want to pick the court where your defendant lives, works, or does business. So if your defendant, for some reason, lives in Henderson, works in Henderson, and never leaves Henderson, never does any business anywhere else, you should probably go ahead and file in Henderson. But if your defendant lives in Henderson, but works on the Strip, which is Las Vegas, then you can file at either one. There's a few differences between the courts, and it's just procedural stuff. There's no preference as to which one's better or worse. It's just they do things a little bit differently. So I like to give you some understanding as to how the different courts do things. When you go to file your complaint, okay, and let's say you're going to file in Henderson or North Las Vegas, they kind of do things the old-fashioned way in that they do all of their filing by paper form, just like courts have done it for many, many, many years. You bring in your original complaint, you'll need a cover sheet, which they'll have there for you, you can fill that out, and you'll need to bring 3 copies with you, and they won't make those copies for you. You need to bring all that with you. You need to bring proof that you mailed your demand letter. You should probably also bring your demand letter with you, and you'll need a filing fee. And when you get to the court in North Las Vegas or in Henderson, they're going to take your paperwork and they're going to put a stamp on the top right corner, like courts have done for a long time. And then they're going to give you copies back that have that file stamp on it. Las Vegas does it a little bit differently, and some people might like this, some people may not like this, but they do what's called e-filing. You need to have an email address to e-file in Las Vegas. What they're going to do is you're just going to need 1 copy, your original copy, the one that you filled out, okay? And when you go there, they're going to scan that paperwork into their system, and they're going to email you a file stamped copy about 1 day later. So Las Vegas does things just kind of via the internet, and North Las Vegas and Henderson do things the old-fashioned ways. So as I said, in Las Vegas, after your complaint is filed, after you've gone there and waited in line and they've taken your paperwork and scanned it into their system, you're going to get an email, like I said, usually within about 24 hours, with a link to a file stamped copy. And it will also have your case number on it and the department that you're assigned to. You now have to print that out, and you have 120 days to go ahead and serve your defendant. You're not going to serve, somebody's going to do service for you, but we're going to talk about that. If you filed your complaint in Henderson or in North Las Vegas, you will have gotten your copies back with the file stamp already on it, and they will have a case number, and they will give you a hearing date right then and there. The hearing date will usually be about 90 to 120 days out in the future, so you'll have about 3 to 4 months. So what makes this a little bit unusual is in North Las Vegas or Henderson, you'll know what your court date is as soon as you file your complaint, okay? In Las Vegas, it doesn't work like that. You need to go ahead and get the defendant served 10 days before that hearing date. After you have your file stamped copy of your complaint, the next thing you're going to want to do, that basically means your paperwork has been entered with the court. You've started a case. You have a case number and everything. Now you have to take that complaint, those documents, and you have to have the defendant served. They have to know about this lawsuit. You have to deliver a copy of the complaint to each defendant. So if you're suing 2 people or 2 companies, each defendant must get their own complaint. Service must be completed by a person who is over the age of 18 and not a party in the lawsuit. So that means that you, yourself, if you are the plaintiff, cannot perform service. You have to get somebody to do it for you. You can use somebody that you know. You can use your friend, you can use your cousin, as long as they're not part of the lawsuit. However, we really do recommend that you go ahead and use the constable or the sheriff's office. It's very easy to do. You just contact them. They do charge a fee, but it's not very expensive, and that is a cost that you can recover if you win. And they know what they're doing, and they're more reliable. So you don't have to, but we recommend that you use the constable or the sheriff's office. Whoever completes service for you, and if you use the constables, they will do this, or the sheriffs, they will do this automatically. But whoever completes service for you must complete what's called an affidavit of service. And it's important that you get that document from the person who did service and file it with the court, because that's your proof that the defendant was served. Okay, so you're going to want to make sure that you get an affidavit of service. And as I said, if you use the constable or the sheriff's, they'll actually usually mail that right to you directly. They already know that you need that, and they'll send that to you. Depending on whether you're serving an individual or you're serving a business, it's a little bit different. When you're serving an individual, it's typical personal service, which means that if you're suing Joe Smith, whoever's doing service for you has to find Joe Smith and walk up to him and hand him the complaint. That's personal service. If you're serving a business, it's a little bit different. So if you're serving your property management company, you have to find out who the registered agent of that property management company is. But it's actually very easy to do. And usually, I would kind of show you how to do this. But what you want to do, you'll notice there that I put the Nevada Secretary of State website. You want to go to that website. And when you go to that website, you'll see business search. And you put in the name of the business, whatever, ABC Property Management Company, and hit search. When you do that, information about ABC Property Management Company will pop up. And right on that first page of information, you should see the registered agent listed there. You'll see their name, and you'll see their address. There may not be a telephone number, but you'll see a name and an address. That is the person that will be served, and that is the address at which they can be served. And that's who you'll go to serve ABC Property Management Company, their registered agent. Of course, you won't do that, you yourself, but whoever's doing service for you. After your complaint has been served on the person or company that you are suing, if you filed your case in North Las Vegas or in Henderson, there's really no other steps. Remember, when you filed your complaint, you already got a court date. So after you perform service, or after you've been sure to make sure that the complaint has been served, you just sit back and wait for that court date. In Las Vegas, it's a little bit different. After the defendant has been served, the defendant has 20 days to file an answer. North Las Vegas and Henderson does not make a defendant file an answer. Only Las Vegas does. They have 20 days to file a written answer. If they file their written answer, the court will automatically schedule mediation. Automatically. And you're going to notice in the mail telling you when your mediation is. If the defendant does not file an answer, you, as the plaintiff, can obtain a default judgment. So you can basically get a judgment for everything that you asked for in your complaint, and you didn't even have to go to court to get it. It's because the defendant failed to respond within the time that they're supposed to. So the next part of this that I'm about to go into is mediation. I just kind of like to give you a summary of where we're at and all the steps that you've gone through. You have figured out who you're suing, and you have figured out how much you're suing for. You drafted a demand letter, you sent it off, you waited 10 days, and let's say you didn't get a response. So now you have to go and file your complaint in the appropriate court. And then you have to get that complaint served on the person, or company, or parties that you're suing. If you did this in Las Vegas, if you filed your case in Las Vegas, now you have to wait 20 days to see if they file an answer. If they do file an answer, now you're going to move forward with mediation. So what is mediation? Mediation is confidential, it is free, it's required, and the agreements that come out of mediation can contain remedies not usually allowed by the court. It's conducted by a neutral third party who tries to help opposing parties reach a mutually agreeable solution. So basically it's where you sit with somebody who's not deciding your case, but just trying to help facilitate an agreement. The court does require you to go to mediation. And therefore they don't charge you for it. And whatever you discuss at mediation should be confidential. You'll notice in the handouts that I gave you, there's a little box there with the Neighborhood Justice Center, the address and the telephone number. When you file your case in Las Vegas, that is where mediation will be held, at the Neighborhood Justice Center. It doesn't matter whether you're in North Las Vegas, Henderson, or Las Vegas. No matter which court you filed your case in, you will have to go to mediation. But again, they do things a little bit differently. You do have to attend, but you don't have to agree, okay? If things don't work out and you try to go back and forth, if you are unable to resolve this, that's fine, then they will just go ahead and proceed. The mediation will send a notice to the court, and the court will go ahead and schedule you a court date. One of the things that I do like to kind of let you know is, when I said earlier that the agreements can contain remedies not allowed by the court, what that means is, if you remember earlier, I told you that if you're really having an issue with your neighbor because his dog keeps getting out and he's doing damage to your yard, and you're mad at Joe because his dog keeps damaging your yard, and what you really want is for Joe to fix his fence so the dog will stop getting out, you can reach that agreement in mediation. Joe can agree to fix his fence in 30 days. And maybe you'll agree to take a little less money for the damage that the dog already did. You can reach that agreement in mediation. If you go to court, remember, the judge can't order Joe to fix his fence. Okay, you can get the money, but you may not ever get the fence fixed. So that's one of the benefits of mediation. In Las Vegas, mediation is going to be a separate date, so it's a separate date all of it itself. You'll get a notice in the mail, and it's usually about 10 to 20 days after the defendant files an answer. So about 2 to 3 weeks after the defendant files their answer is when you'll have mediation. And as I said, it will be held at the Neighborhood Justice Center, which is directly across the street from the courthouse. In Henderson, the way they do mediation is they'll have a brief meeting right before your hearing date. So you'll show up for your hearing date, but before you actually see the judge, you'll have a meeting which will constitute your mediation to see if you can work it out. If you do, they'll just take the hearing off calendar. If you don't, you'll proceed with your hearing. In North Las Vegas, it's kind of similar. You'll show up on your court date, but what that date actually is your mediation date. If you're able to work things out, your case will be resolved. If you're not, they'll set you for the next available court date. So they just do things a little bit differently. If the plaintiff, the person who filed the lawsuit, the person who filed the complaint, fails to appear at mediation, your case will be dismissed. And you'll have to start this whole process all over again. If the defendant fails to show up at mediation, the plaintiff can obtain a default judgment. If you attend mediation, both parties show up, and you reach an agreement, what they will do is you'll sign a new binding contract, and if either party defaults on the terms of that contract, you can reopen your case. So you don't lose your case or the case doesn't get dismissed just because you entered into an agreement, okay? And then if the parties don't follow through with what they promised, you can reopen your small claims case. Now we are going to move on to preparing for court. So this is the final step. One of the things that I do like to recommend is if you, and hopefully your case can get resolved before you have to go to court, but if not, one of the things that's a good thing to do is go watch a small claims case. They have, as I said, they've had them in North Las Vegas and Henderson and Las Vegas. Las Vegas is very busy. They're held in the afternoon. You can just go to the information booth and ask where the small claims courtroom is, and if you go to wherever the courtroom is, if you go and sit there for an hour or two, you'll probably see several small claims cases within an hour or two. It's kind of like watching Judge Judy, but a little more realistic, and it's very helpful to watch how other people perform, because it shows you kind of what to do and what not to do when you watch somebody else do it. So if you have the time to do that, I think it's really helpful. You only get one shot, so you may as well do a little preparation. Also, before you actually arrive at court, there's some things you should have organized for your case and all ready to go. In our materials, we refer to it as an exhibit book. That's just an easy way of referencing it. Here's what you want to do. Let's say you're suing your landlord and you want your security deposit back. What you want to do is, before your court hearing, the night before or a couple of days before, you want to prepare an exhibit book. You want to prepare a nice organized packet of all the materials that you will need for your case. So for example, with a security deposit, you may want to include your lease. You may want to include photos of the unit when you left, that you took when you moved out. You may want to include some receipts for repairs that you had did before you left. And maybe you have your receipts from providing your security deposit. And you want to make photocopies of all of those things and create a little booklet, A, B, C, D, E, and put them all together. Then you want to make 3 exact copies of that. One is going to be for you to use at court, one is going to be for the judge to reference, and one is going to be for your opponent. I can't stress enough how much easier that is going to make your ability to communicate when you actually get into court, because you'll have all your documents in front of you, and everybody who you're speaking to, whether it be to the opponent or to the judge, will have the same documents in front of them at the same time. So everybody can reference the material as you're communicating, and it helps avoid a lot of confusion, and it helps keep you focused on saying what you want to say. So while it stings a little bit to make a copy for your opponent and have to give them your information, it's well worth it, okay? Because no matter what, when you go to small claims and you're in court, whatever you want the judge to see, he's going to let your opponent see. And that's just the way it goes. So you may as well just get it over with. And
Judge Judy is a stickler for that.
Judge Judy does it, okay. So, yeah, and that's the way it works. And so it really helps. So just let it go, make a packet for your opponent, make a packet for the judge, and you'll have everything you need in front of you, and you won't have to worry about any of that. On your day of your hearing, you do want to arrive early for what's called roll call. If the plaintiff, the person who filed this lawsuit, fails to show up, your case will be dismissed. So you went through this whole process, and you'll have to start all over again. So don't miss your court date. Don't even be late. And if the defendant fails to show, then the plaintiff will get a default judgment. The person who filed this lawsuit will get a default judgment. A lot of times what they will do is they will schedule, if your case was scheduled for October 1st, everybody who's scheduled for October 1st is scheduled to arrive at the same time. You may be the first case, or you may be the 7th case. You never know. So number one, plan to be there a while, because you don't really know how long you're going to have to wait till they call your case. And number two, show up at whatever time is on your notice, because you don't know when your case, you could be the first case. And that's it, if you fail to show up and they call your name, doesn't matter that you show up 25 minutes later, you got to start all over again. We tell you to figure on having 10 to 15 minutes for each case. I've seen small claims hearings go longer than that, and I've seen them take just about 10 minutes to get all the way through the issues. There's certain types of cases that small claims judges hear a lot, so they're really familiar with them, so they know how to get right to the point. So the point is, but for you, this is your first experience and your first time, most likely. So practice beforehand, know what you want to say, and be able to get right to the point as quickly as you can, because you may not have as much time as you think. It's not the OJ trial. You might only have 10, 15 minutes to say what you want to say. So practice it beforehand so you can get it out in a short amount of time. And of course, there's basic etiquette that you should practice in any courtroom. Always address the judge as Your Honor or Judge, despite whether it says referee or Justice of the Peace. Just call them Judge or Your Honor. Do try your absolute hardest to not interrupt the judge. I can promise you that even though you might be saying something, if the judge is interrupting you, asking you a question, that's what you should be talking about. Not what you want to talk about, but what the judge wants to know about. That's what the judge might be most interested in. So be sure to pay attention to the judge and try not to interrupt him, and let him ask you questions, or her. You also want to, they're pretty good about letting you know to do this, but you want to hand your evidence to the bailiff. So if there is anything, let's say your exhibit book that you want to give to the judge, just give it to the bailiff. He'll hand it over for you. And do try your best to not interrupt your opposing party. You want to come across professional and grown up. Try to avoid pettiness and looking immature. So try not to interrupt each other, and just be confident in what you have to say, and it will go over a lot better. Also, make sure that you do dress professionally. Dress like you would for a job interview, because don't wear flip-flops, don't wear things like that. Dress like you would for a job interview. It's hard to say sometimes what some judges think is inappropriate, so step it up a little bit with your attire. Okay, so you've gone through this whole process. You had your mediation. Mediation didn't work out. You went to your court hearing. You presented your case, and let's say you won. Well, you're not much interested in appealing, but your opponent has the right to appeal. Or maybe you lost. Maybe you are the plaintiff and you filed this case and you didn't get anything close to what you wanted. Both parties have the right to appeal. How you appeal is, again, a little bit different depending on which court you're in. If you brought your case in Las Vegas at the Regional Justice Center, they have a different kind of appeal process. In that court, your first case was heard by a referee. If your case was first heard by a referee and you want to appeal the decision of the referee, you have 5 days to file what's called a formal objection. So you have a short time span to do this, but it's all very easy. It's a one-page document, fill in the blank. If you file a formal objection, what will happen is you'll get a whole nother bite at the apple, as they say. So you get to do it all over again. Your case will get scheduled for another hearing with a new judge. This time, you will go before a justice of the peace. So the first time you were heard by a referee, the second time you're going to be heard by a justice of the peace. And the justice of the peace is going to listen to your case like the very first time it ever happened, like the first one never occurred, which is pretty unusual in an appeals process. It's a do-over. You get a do-over. If you had filed your small claims originally in North Las Vegas or in Henderson, they don't use referees. So if you want to appeal your decision from North Las Vegas or Henderson, that's a little more complicated. Basically, you are appealing the decision of a justice of the peace to the district court. I won't go into exhaustive detail about this, but it is a more complicated process. You have 5 days to appeal. You would need to pay a filing fee and post a bond. There are several documents that has to be filed, including a notice of appeal, which is the one that has a very specific timeline. And then you'll also have to file what's called an appellate brief, where you would have to lay out a legal argument as to what the justice of the peace did wrong legally. The justice of the peace would have to make a legal error in order for the district court to reverse it. So the bottom line is, it is harder to appeal in North Las Vegas and Henderson. There's a little bit of an easier appeals process in Las Vegas. Hopefully you'll win and you won't need to appeal, but, and as I said, just remember, both sides do have the right, but just so you know, either party can file an appeal after you win at court. So if you went to court and the judge was very favorable to you and issued you a judgment in the amount that you asked for, the hard part to believe is that all you really have is a piece of paper. You've won, the court ruled in your favor, you obtained a judgment, but that's all you actually have is a judgment. It's up to you to go and collect that judgment, and sometimes this can be the hardest part. So you've gone through this whole process, and you made it through mediation, and that didn't work out, and you got into court, and you presented your case, and the judge ruled favorably for you, and now you have a judgment, but now you have to get your money. There's a few things that can be helpful in helping you get your money. The person who won, whoever that may have been, is called a judgment creditor, and the person who lost, who owes the money, is called a judgment debtor. The first thing that we recommend is that you actually try writing a letter. It depends how this is going to go. When you have your hearing that day, it might be that you can step outside the courtroom and make arrangements right there as to when you can collect your payment or where they can mail the check to. But let's say both parties storm off, or the person who lost is mad, and they go down the elevator and you don't see them again for another day or two. You should probably try writing them a letter and asking for the amount of the judgment. Again, be polite, just in case anybody ever has to see this letter. But just basically say, look, I won, you lost. The court awarded me such and such amount of money. Please pay me. I can be contacted at, you can mail the check to, whatever. If the person who owes you money, the judgment debtor, is really blowing you off and doesn't respond to that letter and never responds to you, what you'll have to do is file what's called a writ of execution. A writ of execution is a court order that authorizes the constable or the sheriff to take certain property belonging to the judgment debtor. There are different ways that you can go about doing this, but in some instances you can use a wage garnishment. You can also garnish monies from bank accounts. You can put liens on property. If you don't have all the information you need in order to take this step, let's say you obtained a judgment, and let's say it was against your neighbor, Joe, with the dog. And you know he works, but you're not sure where he works. You can file what's called a motion for examination of judgment debtor, which allows you to find a judgment debtor's property. The court requires the debtor to come in and answer questions under oath, and they can also require the debtor to bring in certain documents. So you file that motion, and in the motion you'll state whether or not you want them to bring certain documents, for example, their last 3 pay stubs, and then they set a hearing on it. The other party gets served with notice of this. And then they set a hearing for it, you'll come into court, and you can ask Joe questions right there in front of the judge about where he works at, whether he brought his last 3 pay stubs. Of course, you can only do this when you've obtained a judgment, okay? But after you've obtained a judgment, if the person will not pay off on it, this is a step that you can take to get a little more information about where to serve a writ of execution. Another thing to be aware of, and this is what we were talking about much earlier on, about judgment proof, is what's called exempt property. Exempt property is property that cannot be taken by a judgment debtor, by a judgment creditor from the judgment debtor. So it's money you can't touch, is the easiest way to say it. There are several classifications of things or several items that fall into this exempt property, but some very common ones are, probably the most common one, is payments and benefits such as Social Security, veterans benefits, unemployment, public benefits, and child support. Those types of payments are 100% exempt. A judgment creditor cannot touch any of those, okay? Another common example is 75% of a debtor's wages. That will, I don't know if you've ever known anybody who's getting wage garnishments, but that's why when they do wage garnishments, they'll do several. They'll do one, and then they'll do another, and then they'll do another. That's because 75% of a person's wages are exempt, can't touch them, but 25% aren't. So you can keep taking 25% until your judgment is paid off, but you can't just take their whole paycheck, okay? And as I said, with those payments from the VA or from Social Security, you can't touch any of that. So, to go back to my original example, if you wanted to sue Joe, your neighbor, and it happens to be that Joe, he's renting the property next door, and he lives off as his veteran's disability, and he owns a piece of junk car, Joe may not have anything, and he may be judgment-proof because he doesn't have any of the kind of property that you can ever garnish from or ever take. So it's something to think about from the onset. If you have a business and whatnot, this is probably not a concern. This is usually more of a concern with an individual person. Some last-minute information about judgments. When an individual, the defendant most likely, is exempt, meaning Joe, let's say we have Joe and he lives off of his VA disability and that's all he gets, he should file something called an Affidavit of Exemption, which is the document that he files with the court to let everybody know, I don't have any money that you can take. It's supposed to be filed within 10 days of receiving your writ of execution. Also, unpaid judgments can be renewed every 6 years, so just be aware that if you do obtain a judgment and you have a hard time collecting on it, and maybe the person who you obtain the judgment against doesn't have anything right now, your judgment will expire unless you renew it before 6 years, okay? So just be aware that they do expire, but they can be renewed. And lastly, if your judgment debtor does go ahead and pay off whatever was owed, you should file what's called a satisfaction of judgment, which is their proof that they paid off their debt, okay? And that would get filed, it all gets filed in the same case. It's one case number. You'll file everything within that case. Lastly is help is always available. In our materials here, you'll see that we've provided you the address and telephone number of the Civil Law Self-Help Center, which is located in the Regional Justice Center, the big Las Vegas court over on Lewis. It's an excellent facility, and they have almost every form you could ever possibly need. What is really helpful is, especially if you don't have a computer at home or it's hard for you to print these forms off, because there is a website I'm about to give you, but if you want to go check out the forms or you don't have a computer to print them off, you can go pick up a copy of almost everything you should need for your small claims at the Civil Law Self-Help Center. I do like to let you know that they can't give you legal advice, okay? But they can help refer you to certain laws and certain procedural information that can be helpful to you as you navigate through this process. You're also always welcome to come back to this class as many times as you like. The website that I want to tell you about, it is in your materials. It's www.civillawselfhelpcenter.org, all one word. That is the website for the Civil Law Self-Help Center at the Regional Justice Center. And almost all the forms are available on that website for small claims. You can print them off, and they're even PDF fillable, so you can actually type them right on your computer and print them off. It's nice and neat. And it has, I've never not found what I didn't need on there. Everything that you should need should be there. And there's no charge. It's free. I think that's all the information that I have. Thank you for coming to the class.